Lawyer Jiang Jie, in the case of Xu Ting, stealing the bell while covering one's ears is not stealing? Author, Jiang Jie, lawyer at Beijing Jiang Jie Law Firm. This article was published in the second issue of Beijing Lawyers in 2008 and on the website of China Lawyers. The original title is, Who Did Xu Ting Offend? Some views on the Xu Ting case. The original text is as follows. Legal experts, scholars, and the public have expressed their views on the Xu Ting case. The views of legal experts and scholars are summarized as follows. Advocate that the crime of theft is not established. Professor He Guiyun of China University of Political Science and Law believes that Xu Ting's behavior is neither unjust enrichment nor theft, but a completely new behavior. Xu Ting's behavior is not secret theft. The so-called secret theft is intended to hide the identity of the person who obtains the property and prevent the owner, possessor or custodian of the property from knowing who took it away. Xu Ting obviously did not hide his identity, because he used his own real credit card to withdraw money, so the ATM machine would record his account number, and the bank could find his name, address and ID number based on his account number. This is equivalent to telling the bank when he withdrew money, the money was taken by me, Xu Ting. This is certainly not stealing secretly, but obtaining it openly, so it cannot be considered as theft. Lawyer Tianwen Chang, in general, such behavior is definitely harmful to society, and it violates both morality and law. The acquisition of property is obviously an unjust enrichment, which should not be controversial. As for how to characterize it at the level of criminal law, it should be analyzed in combination with the specific provisions of the legal provisions. If this behavior constitutes a crime, it is nothing more than three situations. One is theft, the second is fraud, and the third is embezzlement. The controversial views in society at present mainly involve these three crimes. In this case, when the perpetrator used his own card to withdraw money from the ATM, he did not tamper with the card or the ATM, and operated completely in accordance with normal and proper procedures. This shows that he did not implement the theft methods clearly stipulated by the law, that is, he did not steal secretly. In this case, although he had the motive and result of possessing this ill-gotten wealth, it is obviously reluctant to identify it as theft according to the principle of legality of crime and punishment. To give an analogy, if the bank card is regarded as his own cash box, or bank safe, it is of course legitimate for him to take money from his own cash box at any time, but if he steals other people's money and puts it into his own cash box, it is theft. However, if someone else took the initiative to put money into his cash box by mistake, and he took more money when withdrawing money knowing that it did not belong to him, this behavior does not meet the characteristics of theft, because he did not commit the means of theft stipulated by law. In fact, the situation in this case is like the relationship between a big cash box and a small cash box. The bank card of the perpetrator is like a small cash box, and the bank's ATM system is like a big cash box. According to the design procedure, the bank divides the money from the big cash box into the depositor's small cash box according to the amount of deposits deposited by the depositor. However, due to a system failure, the big cash box put too much money into the small cash box, or there was a loophole in the channel from the big cash box to the small cash box, and some money flowed into the small cash box. This situation is the same as the counter operator taking more money when the depositor withdraws money, and the fault does not lie with the withdrawer. This phenomenon is not uncommon, but it is impossible to convict the person who took advantage of the withdrawal of the money as theft. Advocate for the establishment of theft. Qian Liang, in terms of characterization, I think there is no problem that Xu Ting's behavior constitutes theft, and he stole from a financial institution and the amount of theft was extremely large. The author agrees with the view of lawyer Qian Liang that the crime of theft is established. The following is my own opinion on the conflicting opinions and views, and discusses with Professor He Guiyun and lawyer Tianwen Chang. Xu Ting's behavior has the characteristics of secret theft, and the reason is that no one was present at the time of withdrawal. Imagine if someone found out, would Xu Ting still withdraw 175,000 yuan? No. Professor He Guiyun believes, Xu Ting obviously did not hide his identity, because he used his real credit card to withdraw money, so the ATM machine would record his account number, and the bank could find his name, address and ID number based on his account number. This is equivalent to telling the bank when he withdraws money, "The money was taken by me, Xu Ting." This is certainly not secret theft, but public acquisition, so it cannot be considered theft. Professor Ho Guiyun's view actually equates machines with people. The so-called secret theft refers to the relative natural person, that is, not to let people find out, so as to obtain property smoothly. It does not include ATMs and cameras discovering. For example, a factory warehouse is equipped with camera monitoring equipment. The factory worker Li knows that the warehouse is monitored by cameras. Li, without any disguise, sneaks into the warehouse at night and steals the warehouse materials. The existence of the camera, equivalent to Li telling the factory that the materials were taken by me, Li, does not affect Li's theft crime. Does it mean that because of the existence of the camera, Li is taking it publicly and does not constitute theft? Lawyer Tian Wenchang believes, if the bank card is regarded as his own cash box, or bank safe, it is of course legitimate for him to take money from his own cash box at any time, and if he steals other people's money and puts it into his own cash box, it is theft. However, if someone else took the initiative to put money into his cash box by mistake, and he took more money when withdrawing money knowing that it did not belong to him, this behavior does not meet the characteristics of theft, because he did not commit the means of theft stipulated by law. In fact, the situation in this case is like the relationship between a big cash box and a small cash box. The bank card of the perpetrator is like a small cash box, and the bank's ATM system is like a big cash box. According to the design procedure, the bank divides the money of the big cash box into the depositor's small cash box according to the amount of deposits deposited by the depositor. However, due to a system failure, the big cash box put too much money into the small cash box, or there was a loophole in the channel from the big cash box to the small cash box, and some money flowed into the small cash box. This situation is the same as the counter operator adding more money when the depositor withdraws money, and the fault does not lie with the withdrawer. The author does not agree with the metaphor and viewpoint of lawyer Tian Wenchang. 1. A bank card is a bank card, not a small cash box. There is no money in the small cash box, only data. This is a mistake of stealing concepts. Although everyone usually says how much money is in the bank card, the actual money is still in the bank. 2. Xu Ting's withdrawal from the ATM is absolutely not the same as the counter operators adding more money when the depositor withdraws money. The former is the consequence of Xu Ting's behavior. It is definitely not that someone took the initiative to put the money into his small cash box by mistake, but that he withdrew it from the big money. The latter is the consequence of the behavior of the bank staff. In addition, Professor Ho Guiyun believes that some other criminal law theories can also lead to the conclusion that Xu Ting did not commit a crime. For example, according to the theory of expected possibility, we cannot expect Xu Ting not to do this when encountering such a situation, so he should not be punished for a crime. According to the theory of criminal law restraint, Xu Ting's behavior can be solved without the use of criminal law, so criminal law should not be used. According to the theory of the purpose of punishment, not punishing Xu Ting's behavior criminally can also achieve the effect of preventing such behavior from happening again, so criminal punishment should not be given. If we stand higher and look further, and use criminal law theories to guide practice, we will find that it is correct not to punish this case as a crime. The author believes that according to the theory of expected possibility, Xu Ting's behavior should be punished as a crime. The theory of expected possibility comes from the judgment made by the German court on the horse habit case in 1897. The perpetrator has been employed to drive a two-horse carriage for many years, and one of the horses has the habit of wrapping its tail around the reins and pressing down the carriage. The perpetrator asked to change the horse many times, but the employer did not agree to his request. One day, the horse got into a bad temper. The driver took all emergency measures, but the horse still hit someone. The court ruled that the perpetrator was not guilty, on the grounds that it was difficult to expect the defendant to resolutely disobey the employer's orders and fulfill his obligation to avoid the consequences of the foreseen harmful behavior at the cost of losing his job. If the perpetrator violated the norm under necessity, such as external pressure, etc., the perpetrator cannot be blamed. If the perpetrator is subjectively driven by interests and wants to commit a crime, this theory cannot be applied. 1. Expected possibility refers to the situation where, based on the specific circumstances at the time of the behavior, it can be expected that the perpetrator will not commit an illegal act but a legal act. Professor Ho Guiyun believes, we cannot expect Xu Ting not to do so when encountering such a situation, and he should not be convicted of a crime. According to Professor Ho Guiyun's logic, rapists commit rape because they are tempted by the beauty and sexiness of the victim, not the victim's active seduction, and thieves enter other people's homes because there is no one, creating an opportunity for the suspect to take advantage of, and commit theft, and they can be exempted from punishment. In this case, it is entirely possible to expect Xu Ting not to steal ill-gotten gains, but to notify the bank or call the police. 2. When Xu Ting withdraws money, he is completely driven by his own interests and takes the initiative to commit the crime. Therefore, this theory cannot be applied and he will not be punished. 3. The theory of criminal law restraint applies to legislation, but not to judicial practice. 4. It is difficult to achieve a preventive effect without punishment. Admittedly, sentencing Xu Ting to life imprisonment is relatively heavy. I think it should be changed to a fixed-term imprisonment of 5 to 7 years. If the loss can be recovered, a fixed-term imprisonment of 3 years is also acceptable. A sentence of 10 years for causing losses. The reasons are as follows. 1. The damage of the ATM is a condition that leads to Xu Ting's crime, which is less subjective than premeditated crime. Who did Xu Ting offend? If the ATM is not broken, Xu Ting will not commit a crime. 2. Public opinion is also worth considering, that is, the social effect. Although many people who originally supported Xu Ting changed their positions because of Xu Ting's outrageous remarks in court. 3. Compared with corruption and robbery, the social harm of theft is much smaller, but the punishment is not light. 4. All human nature has its flaws, and their feelings are pitiful. Although they cannot be exempted from the crime, it is right to reduce the punishment. Finally, I want to say that Professor Ho Guiyun and lawyer Tianwen Chang are both legal experts. If they were in the Anglo-American legal system, their defense might create case law, but it certainly cannot be done in China's statutory law environment. The development of the Internet will surely play a greater role in promoting the development of society and democracy. The retrial of Xu Ting's case benefited from the Internet. Practice will prove that the trial results will also benefit from the Internet. Jiang Jie / Beijing Jiang Jie Law Firm. March 16, 2008.